So I want to do a little bit of a rewind for you before we get into talking about what's going on with this new investigation that's going to happen to Fani Willis. So as we know, Fani Willis has been going back and forth with Ashley Merchant. She doesn't want to reveal certain information and certain conversations she had with a certain someone. We'll get into that in a second. Anyway, so Ashley Merchant, she was fighting. She wanted certain emails revealed. And then we also had the Judicial Watch. They were fighting to have information released that already should have been released by Fani Willis's office, according to the Freedom of Information Act. Fani was fighting it. And Judicial Watch had to go through the entire legal process just to get something that they were legally allowed to have. Again, nobody's surprised about that. So moving forward now, Judicial Watch, they were awarded $21,578 in fees and costs in the open records lawsuit. So basically what I just mentioned. Now, that interesting thing about that is I previously thought this was going to be paid by Fani Willis. No. Guess who's going to pay that? Me. All the Fulton County residents are going to pay this $21,000 to Judicial Watch for them not being able to get some open records, which is unfortunate. So now we move forward. We've got this statement from Judicial Watch when they're talking about what's happening with Fani Willis and a lot of these other lawsuits moving forward. So check this out.
Fani Willis is one of the top abusers of President Trump and many other innocent Americans down there in Fulton County. Has she and her colleagues there, as I say, in league with, because it's been confirmed, by the way, she does have documents showing collusion with Nancy Pelosi's January 6th committee to get Trump and who knows who else.
Crazy.
It's been confirmed as a result of our lawsuit. So she's one of the top abusers of the First Amendment in that regard, because it's a retaliation for exercising your First Amendment and other civil rights.
Yep. And we're going to get into an article here from Law and Crime in a second. But he also says that Fani Willis, she's scared right now, because one of the things that Judicial Watch is asking for moving forward is that a special master be assigned to cover, we'll say, this transfer of information and everything that's going to go on between Fani Willis and all the documents that she's allowed or supposed to release. So check this out from Judicial Watch.
Of course, we still, despite getting this $22,000 nearly from the court or through this court order, we still want the documents they're withholding. And we've asked the court for a special master, which would be a special court, someone with authority under the court to monitor and basically manage the search for records. We've asked the court to look at the documents that have been withheld as well, to see if the withholdings they're citing or the exemptions they're citing as justification for withholding the records are sufficient and warranted, and whether we should get the records or not. I mean, our goal in the end, this isn't about the money. This is about getting the records. Of course,
Now, when Fani Willis found this out, what do y'all think she said? Do you think Fani said, hey, you know what? I didn't do anything wrong. I've been walking a straight line this whole time.
Stop the cap.
Go ahead. You want to bring in a special master? Go ahead. You know what? Get somebody from Trump's office to investigate this. I don't care. I'm Fani Willis. I've been doing my job. That's not what she said. Check this out. This is an article by Law and Crime, and shout out to Law and Crime. What do they say? Fani Willis says this is, quote, incredibly intrusive. What? Fani Willis pleads with the court not to appoint a special master for repeatedly violating open records law over the January 6th committee documents. Here we're going to get into it. Fulton County District Attorney Fani Willis recently asked the court in Georgia not to appoint a special master in her response to her office's repeated violations of the Peach State's open record laws. As Law and Crime previously reported, those violations occurred when the prosecutor's office, in response to open records requests, denied having any documents showing any communication with special counsel Jack Smith or members of the since defunct House Select Committee investigating the January 6th attack on the Capitol. Late last year, in response to a lawsuit filed by conservative government watchdog group Judicial Watch, Fulton County Superior Court Judge Robert McBurney ordered the district attorney's office to provide the requested documents and or explain its continued absence, leaving open the possibility of attorney's fees. And they actually, Fani Willis and the DA's office, changed their story so many times during these proceedings. It's ridiculous that they're getting away with this. After the prosecutor was found in default, Judicial Watch filed a separate motion asking the court to appoint a special master to scour the agency's files for the documents, or in the alternative to conduct an in-camera inspection of the documents in question. Earlier this month, the judge assessed an award of, we know, the $21,000 in attorney's fees and the cost for the plaintiffs due on January 17th. Willis filed her office's response to the special master request the same day. Now, the embattled DA says she and her office are in compliance with the court's December 2024 order and argue that Judicial Watch is simply asking the court for too much too soon. What? Fani Willis says she wants y'all to stay up out of her business. Plaintiff's request for in-camera inspection of the records that are attorney-client privilege and attorney work product is premature without the opportunity to first have an evidentiary hearing, and there is no provision for in-camera review of documents withheld due to the pending investigation or prosecution of criminal or unlawful activity, the motion argues. Which is a wild statement on their part. Willis also says the law does not allow the relief being requested. The appointment of a special master in an open records case is not provided for by statute, unprecedented under the law, and overly intrusive, the motion continues. Again, she doesn't want them all up in her business. In the court's order finding Willis in default, Fulton County Superior Court Judge Robert McBurney ordered the DA's office to provide an explanation for any documents they continue to withhold. And we even saw this in the Y&W Melly case. They were looking for a search warrant. The defense said, we need to see this search warrant so our client can decide if he wants to keep Raven Liberty on as counsel. And the state said, no, we're not giving it to you. We don't want to do it. It might be a part of an investigation. It's going to be an issue. Judge Fiend said, you need to give it to them. The state came back and said, no, we're not going to do it. Okay, judge said, that's fine. I'm going to order you to do it. And then the defense is going to file a motion. They're going to say, we want this to be provided. And the judge granted their motion. So now they have to do what the judge says. It's the same thing with Fani Willis. In regards to the document related to the since resigned special counsel, Willis said she submitted a letter stating that there are no responsive documents in regard to the January 6th committee documents. Willis said they were being held because they are exempt pursuant to a section of Georgia law. Plaintiff's motion must be denied, the motion argues. Judicial Watch, for their part, has expressed a certain level of doubt about the searches conducted by the Fulton County DA's office. The group's motion filed on December 17, 2024, says that Willis's response to McBurney's makes no showing that the search was diligent. And they lied initially about the information being there in the first place. Based on her previous searches in this matter, it probably was not diligent, the motion reads. I agree. Likewise, she provided no list or even a general description regarding any responsive records she had elected to withhold. Without a list or description, it is impossible to evaluate what, if any, exemptions or exceptions are applicable, as she now contends. Judicial Watch notes that Willis admittedly conducted at least 3 searches before finding any responsive records not already supplied by the watchdog group itself in the litigation. aiming to raise questions about the basic competency of those working in Fulton County's district attorney's office. And we even saw it when Ashley Merchants had a couple of people from the district attorney's office on the stand. They were running around like crazy, just trying to say that they didn't need to provide certain pieces of information. Such competency issues, the group says, means a special master is needed. They might be right. The foregoing gives rise to grave suspicion that all responsive records have not been found. The court should appoint a special master to supervise and monitor the record searches. The special master should have authority to audit the searches. Oh, gosh, that's going to be bad. And conduct searches herself. She also should have the authority to hire such consultants and experts as may be needed to execute her commission. The special master should make a recommendation to the court as to how her fees and expenses should be allocated among the parties, taking into consideration whether she finds responsive records that Willis should have found but did not. And it's funny, even about the some of the emails and information they were looking for. At first, Fani Willis said, "Oh, we don't have it," and then all of a sudden they said, "Oh, you know what? We might actually have something here." In her response, Willis argues the Open Records Act, the law she violated, does not entertain the possibility of a special master being appointed in order to remedy violations. Defendant vigorously objects to the appointment of a special master in the Open Records lawsuit because it is not a form of relief provided under the Open Records Act. It is unprecedented. Well, so is this case. And it is incredibly intrusive. The Willis motion continues. The plaintiff points to no authority that substantiates appointing a special master in Open Records case is a proper form of relief by the court or under the Open Records Act. Well, if you don't do your job, Fani, you got to get somebody else to do it for you. It's not that complicated. The district attorney goes on to say the appointment of such a special master would itself violate the law and would impair the integrity of the pending and open criminal case. Now, the criminal case she's talking about is the case that's most likely going to be thrown out, the case against Donald Trump, right? So this is all going to be a mess. And if that happens, then I want to see what their argument's going to be. Y'all have to let me know what you think in the comments and in the chat. How is this going to go moving forward? And should Fani Willis be worried? Because if you get a special master and they start looking through some of the documents there, they might see some things that won't be good for Fani Willis in the DA's office. Let me know what y'all think.